On 31st of August 1994, the Supreme Court of Pakistan held that in bailable offences, the grant of bail is a right and not a favour, whereas in non-bailable offences, the grant of bail is a concession and not a right. Section 497 Criminal Procedure Code divides non-bailable offences into two categories. Offences punishable with death, life imprisonment, or imprisonment for 10 years. Bail can only be granted if there are no reasonable grounds to believe that the accused is guilty. Offences punishable with imprisonment for less than 10 years. Bail is the rule, and refusal is an exception, which can only be justified in extraordinary circumstances, such as likelihood of absconding, apprehension of tampering with evidence, danger of repetition of the offence, or previous conviction of the accused. Held in petty offences, accused should not be unnecessarily detained, and courts should consider releasing under-trial prisoners on personal bonds if they are unable to furnish sureties. Section 497. 2. Further inquiry. Benefit of doubt. Grant of bail. Where the material on record does not provide reasonable grounds to believe in the accused's guilt, but rather indicates a case of further inquiry, bail should be granted. The court at the bail stage should only make a tentative assessment of the evidence and should not conduct a preliminary trial. Deep appreciation of evidence is neither desirable nor permissible at this stage. Held benefit of doubt regarding occurrence itself, identity of the accused, role attributed to the accused, presence at the scene, or vicarious liability should be extended to the accused even at the bail stage. A person should not be kept behind bars if reasonable doubt exists about his participation in the offence. Cancellation of bail, legal principles. Difference between grant and cancellation of bail. The principles for granting bail and cancelling bail are distinct. Once bail has been granted by a competent court, it can only be cancelled on strong and exceptional grounds. Cancellation should not be used as a punishment. The mere seriousness of the charge is not a sufficient reason to cancel bail, unless there is misuse of bail conditions, or subsequent discovery of material evidence against the accused administration of justice bail, jurisprudence overcrowding in jails, need for judicial leniency in petty offences. Many under-trial prisoners remain incarcerated due to their inability to furnish sureties, despite being entitled to bail. Courts should ensure that trial judges consider the propriety of release on personal bonds in bailable and minor offences. Held unnecessary detention of under-trial prisoners burdens the public exchequer, and judicial officers should avoid excessive severity in bail matters. Under-trial prisoners are entitled to food and medical facilities under Section 32 of the Prisons Act, 1894, and such rights should be respected. Access the full judgment on www.paclegaldatabase.com